Hi, this is Kathy Hanvo with another hot topic in California law and ethics, an introduction to subpoenas. And of course, I just need to let you know that I am a therapist just like you. I am not a lawyer. This is not legal advice. It's just meant to give you a little bit of an overview because I see a lot of misinformation out there around this stuff. But one of the things, and I will probably say this more than once going through this video, if you get a subpoena, my advice to you is to contact your malpractice insurer and let them walk you through it. Depending on the situation, they will provide a lawyer for you. That's what you pay for malpractice insurance for. So use them as a resource. So what are the 5 factors you need to take into consideration if you receive a subpoena? Your code of ethics, HIPAA, state law, whether the client wants you to release the information or not, and if you work for an agency, any agency policy. And that's just one of my learning objective check-ins. That was a learning objective 5 factors that need to be taken into consideration when a subpoena is received. The ethical standards related to subpoenas are mostly around confidentiality. I have put them all in the packet, and I will let you read them yourself because they're lengthy and you don't need me to read them for you. I do think it's always a good idea to go back and read our code of ethics every so often. You'll see that with NASW, it is very lengthy. Here we go. And then there's CAMPS, which is a little less lengthy, and ACAs, which is also a little bit lengthy. And you'll see on this last page here, they actually have something specific to court order disclosure. The next factor is HIPAA. So HIPAA fits in because the privacy rule states that to respond to a subpoena, you must either have a court order mandating the release or receive a written document from the client agreeing to said release. And then also number 3, which is receive documentation that reasonable efforts were made to contact the person whose records are being sought. You know, it's interesting because sometimes you have to go with the most restrictive rules. So number 3 is something that HIPAA says is okay, but our code of ethics is, a little iffier on that. What is privilege and how does it fit in? Privilege is a rule around evidence, and it refers to the right of the holder of the privilege, so the client, usually, to refuse to disclose or to prevent somebody from disclosing confidential communications in a legal proceeding. So the client has the right to allow or deny their therapist to share their records. If they invoke their privilege, the therapist cannot release any information without being ordered to do so by a judge. The therapist must invoke privilege and tell the courts that, and then the courts decide. And if the court orders you to release the information, you do have to release the information, but the judge is deciding, not you. For a minor, the privilege may not be held by the parents, so you need to establish who the holder of the privilege is. Could be the child's attorney or someone else, so just make sure you know that. There are a few exceptions to privilege. If a client has a case where their mental health status is relevant, they cannot keep records from being released. Now, they might ask you to invoke privilege, and if they ask you to invoke it, you should invoke it. But a judge, if they're suing, their employer for mental, strain or emotional stress or something, a judge is most likely going to order the records to be released. But again, let the judge make the decision. If they sue you, they also cannot keep records from being released. But again, you should invoke the privilege and let the courts decide. So 2 things can happen with a client privilege. A client can waive privilege, and when they do that, they are authorizing you to release the records. And as a therapist, you want to have that in writing. And I would get, this is why it's good to have a lawyer. I had to deal with this once, and the lawyer actually wrote up a release and used language about privilege in particular, not just about releasing records. And the opposite is they can invoke privilege, in which case they are telling you to refuse to give the records. Privileges for minor and mentally incompetent adults, and that's a legal term. So for a minor, the first step is to always assert privilege unless the person who holds the privilege waives it. So again, it could be the parent, the minor's lawyer, a guardian ad litem. You need to figure that out. And there are very few circumstances where a minor can invoke or waive their own privilege. If they're involved in a dependency hearing, California law believes that a child above 12 can invoke a waived privilege. For mentally incompetent adults, the privilege is held by their legal guardian or conservator. And again, as I talked about before, these are the exceptions to privilege. And it's never up to us to decide whether they can assert it or not. If they tell you to assert it, you assert it, and the judge decides. What about psychotherapy notes? There's a very long definition of psychotherapy notes, and they need to be kept separate. And it talks about what they are and what they are not in this long definition. But HIPAA does require that if there is a subpoena, psychotherapy notes need to be named specifically before releasing them. If a client requests their release, it should also spell out that those notes will be given. There was a court case where a therapist declined to release psychotherapy notes and was ordered to do so. That's Evanson versus Hartford Life Annuity Insurance Company. So this was an interesting case because a woman sued the insurance company on behalf of her husband's estate. He died, and the insurance company declined to pay out, I guess, his life insurance benefits because they thought that he had lied about his history of treatment for alcohol addiction. They subpoenaed his treating therapist for records. The therapist sent some records, but not all records. The insurance company requested that the wife sign a release for all records, which she did. The therapist refused to release them again and argued that HIPAA states patients don't have a right to psychotherapy notes, that they should not have to be released to a litigant, that the notes were her personal property, and the court ruled against her. So it's just important for you to know that no records are immune from disclosure if a judge orders them. So even if you keep psychotherapy notes, a judge could still order you to release them. And this is why some experts say don't keep those notes. Subpoenas. So the types. You have them for records, for testimony, which could be in a trial or in a deposition, or for both. So your options for responding to a subpoena with client consent is having them sign a statement to that effect, saying that they're giving up their privilege, full information on what's released, and making sure that they understand the consequences of releasing the information. Lots of times when you get a subpoena in the mail, they're going to have a release in there. I feel like it's always best practice for us to communicate with the client directly. That's what makes me feel better. But again, not a lawyer. If a subpoena does not have the client consent, or you're not able to reach the client, you must assert privilege. And if there's a release enclosed but you're unable to contact the client, again, this is a place where you want to talk to a lawyer. There's a long California code on responding to subpoenas, but basically it says that if the client wants you to assert privilege, you assert privilege. There's this bizarre kind of law that was done in the Patriot Act, which at one point allowed the FBI to request subpoenas from a special court, and they wouldn't even actually let a therapist go to a lawyer. But that got modified in 2006. So if you were to get some sort of a Patriot Act subpoena, you can fight that in a FISA court. Hopefully that's not something most of us will ever have to deal with. Some of the ethical codes actually address this. The APA clarified their stance on this in section 1.02 as quoted below, and stated that if the therapists are following the law, they can't be ethically sanctioned for it. So what's California law and legal cases on confidentiality? And this is just a whole lot of law you can talk about. I have highlighted certain parts. And again, I'm gonna just, this gives you a lot of definitions and stuff. It's actually worth reading. I know we don't always want to read these things. And again, I bolded some certain parts that I thought were especially relevant to us as therapists. All right, we're just going through this. As you can tell, it's pretty long again. Sorry, I should have seen where I needed to skip to. All right. This is an interesting case, the Supreme Court case holding for confidentiality. It's Jaffe versus Redmond. It was a 1996 case. Redmond was a police officer who shot a person in the line of duty. Jaffe was the executor of the dead person's estate and sued because of the shooting. And during the discovery, it was found that Redmond had seen a licensed clinical social worker. So they subpoenaed those records. At this time, before this case, there was no privilege option, and if you did not release records, it could be held against the defendant, which is exactly what happened at trial. The court found against Redmond and awarded the estate over $500,000. This got appealed to the Seventh Circuit and then to the Supreme Court. The Seventh Circuit overturned the ruling and said that each state individually recognized privilege. Got appealed again to Supreme Court, and they stated that the federal rules of evidence established a right to confidentiality. Justice Stevens delivered the 7-2 opinion and said the following: "This case amply demonstrates the importance of allowing individuals to receive confidential counseling. If the privilege were rejected, confidential conversations between the psychotherapists and their patients would surely be chilled." So you have some rights in California when being served a subpoena. You have the right to be personally served. And there was a case here that talking about the therapist was served by the lawyer, and they were held in contempt because they didn't go to court, and it was overturned on appeal. It doesn't mean you can evade the server if they're trying to serve you. For criminal and juvenile subpoenas, they can serve by mail, but only if you choose to acknowledge it when you receive it. If you are served improperly, you can either treat the subpoena as if it was served validly, or you can call the lawyer serving it, tell them you weren't served properly, and then they have to serve it again. So, ultimately, you're probably going to get served, so you can figure out what to do with it. Again, talk to your malpractice insurer lawyer about those things. And there are some great articles that CAMFT had around subpoenas that I encourage you to look at. All right, thanks for listening, and I hope you found this helpful.